as sole proprietorship. Five interesting sections of Resa or RA 9646 that you might not know about. Hello Real Estate, George here, a PRC accredited and DHSUD registered salesperson under license number 0021980. And today, let's talk about 5 interesting sections about RA 9646 or the Real Estate Service Act of the Philippines or Resa that you might not know about. But before we proceed, if you're new to this channel and have not subscribed yet, please don't forget to hit on the subscribe button and the notification bell so you'll be notified for any future videos coming up from this channel. So, what is RA 9646 or the Real Estate Service Act of the Philippines? Now, for those not familiar, the Real Estate Service Act or Resa is an act regulating the practice of real estate service in the Philippines, creating for the purpose a professional regulatory board of real estate service, appropriating funds, therefore, and for other purpose. And just to give you a brief background on the history of the real estate profession, and I quote this from Inquirer.net, prior to 2009, the licensure of real estate brokers was governed by the Department of Trade and Industry, and the requirement of a license was only necessary if one would be establishing a brokerage firm. However, the thriving property sector in the Philippines, highlighted by the proliferation of high-rise developments, has brought to the limelight the attractiveness of the real estate service as a profession among Filipinos, and hence there was the motion to professionalize the real estate service industry via a legal clause requiring all its practitioners to be registered and licensed in conjunction with the law's explicit objective of enhancing government income in the form of taxation. End of quote. That was how the RA 9646 came into being. Now, 11 years in its implementation and the real estate industry ballooning into a 760 billion peso industry, let us look at 5 interesting sections of the law that you might not know about until now. Let's begin. Number 1. According to Section 3, letter G, we know that there are 5 types of professionals who are considered to be in the practice of real estate services. These are the real estate consultants, real estate appraisers, real estate assessors, real estate brokers, and the real estate salespersons. If you are not part of these 5 types, you are not allowed to practice real estate. But did you know that there are exceptions to this rule? Yes! That is stipulated in Section 28 of RA 9646, as it talks about the exemptions from the acts constituting the practice of real estate service. The provisions of RA 9646 and the IRR shall not apply to the following. Letter A. Any person, natural or juridical, who shall directly perform by himself or herself the acts mentioned in Section 3 hereof with reference to his or her or its own property, except real estate developers who are registered and regulated by HLURB. Letter B. Any receiver, trustee, or assignee in bankruptcy or insolvency proceedings. Letter C. Any person acting pursuant to the order of any court of justice. Letter D. Any person who is a duly constituted attorney in fact for purposes of sale, mortgage, lease, or exchange or other similar contracts of real estate without requiring any form of compensation or remuneration. And letter E. Public officers in the performance of their official duties and functions, except government assessors and appraisers. So, if you are selling your own property, you can do so without violating any law. And even if you don't own the property but is assigned as an attorney in fact through an SPA, you are also not violating the law. But if you don't own the property and without an SPA and you are engaged in the practice of real estate service, even if it's not selling, like leasing and subleasing. You need to be a licensed real estate professional as mentioned in Section 3 of RA 9646. Number 2, you might have noticed that during a project launching or an open house event that a foreign national is acting as a real estate practitioner and wonder if he or she is allowed to practice real estate in the Philippines because you thought only Filipinos are allowed to sell or market real estate in our country. So what does RA 9646 say about that? While the law should only apply to Filipino citizens, Section 24 of the Resa law also mentions about foreign reciprocity that says no foreign real estate service practitioner shall be admitted to the licensure exam or be given a certificate of registration or a professional identification card or be entitled to any of the privileges under this act unless the country of which he or she is a citizen specifically allows Filipino real estate service practitioners to practice within its territorial limits on the same basis as citizens of such foreign country. So, if a foreign national wants to practice the real estate profession in the Philippines, he or she must prove that the country where they came from also allows Filipino citizens to practice the same within its jurisdiction. They also need to apply for a special temporary permit or STP to practice real estate in the Philippines. The STP is specified in Section 23 that upon application and payment of the required fees and subject to the approval of the Commission, the Board may issue a special or temporary permit to real estate service practitioners from foreign countries whose service are urgently needed in the absence of unavailability of local real estate service practitioner for the purpose of promoting or enhancing the practice of the profession in the Philippines. Number 3, what if you are a freelance real estate agent, meaning an agent without a signing broker? What can you do without violating the law? I will answer that based on Section 29 on what you cannot do. Section 29 on the prohibition against the unauthorized practice of real estate service mentions that no person shall practice or offer to practice real estate service in the Philippines or offer himself or herself as real estate service practitioners or use of the title, word, letter, figure, or any sign tending to convey the impression that one is a real estate service practitioner or advertise or indicate in any manner whatsoever that one is qualified to practice the profession or be appointed as real property appraiser or assessor in any national government entity or local government unit unless he or she satisfactorily passed the licensure examination given by the board except otherwise provided by this act, a holder of a valid certificate of registration and professional identification card or a valid special or temporary permit duly issued to him or her by the board and the commission. And in the case of real estate brokers and private appraisers, they have paid the required bond as hereto provided. Section 31 also mentions that no real estate salesperson either directly or indirectly can negotiate, mediate, or transact any real estate transaction for and in behalf of a real estate broker without first securing an authorized accreditation as a real estate salesperson for the real estate broker as prescribed by the board. Number 4, let's say you want to test the law. What are the penalties of violating the law? Section 39 on the penal provisions mentions that any violation of this act, including violations of implementing rules and regulations, regardless of how big or small, shall be meted the penalty of a fine of not less than 100,000 pesos or imprisonment of not less than 2 years or both upon the discretion of the court. In case the violation is committed by an unlicensed real estate service practitioner, the penalty shall be double the aforesaid fine and imprisonment in case the violation is committed by a partnership, corporation, association, or any other juridical person. The partner, president, director, or manager who has committed or consented to or knowingly tolerated such violation shall be held directly liable and responsible for the acts as principal or as a co-principal with the other participants, if any. And lastly, how can we not mention Section 32 and why it is the most controversial section of RA 9646? So, what is Section 32? Section 32 is the corporate practice of the real estate service. It is stated in letter A that no partnership or corporation shall engage in the business of real estate service unless it is duly registered with the Securities and Exchange Commission, or SEC, and the persons authorized to act for the partnership or corporation are all duly registered and licensed real estate brokers, appraisers, or consultants, as the case may be. The partnership or corporation shall regularly submit a list of its real estate service practitioners to the Commission and to the SEC as part of its annual reportorial requirements. There shall at least be one licensed real estate broker for every 20 accredited salespersons. Now, this section is very controversial because of two factors. The one is to 20 broker to accredited salespersons, and if this covers all brokers or just brokers registered with SEC as partnership or corporation. Some interpretation of this law is that this 1:20 ratio covers all brokers, while there are also opinions that the 1:20 only covers partnerships and corporations and do not include brokers registered as sole proprietorship and even limited liability company or LLC. And that is beyond me, so I will leave it at that. But did you know that there is an ongoing petition to amend the Resa law to make it a better law? To get to know more about it, you can visit www.ABetterRealEstate.ph and click on the FAQ button to know more about the movement. So, there you have it, and I hope you learned something new. Once again, this is George Ryan Sarmento, Unit Manager from Filipino Homes and a PRC accredited and DHSUD registered salesperson. Thank you for watching. Stay safe, stay at home, and peace.